Good morning, everyone. I'm Sarah Green Carmichael with Bloomberg Opinion. We're here today to talk about the Trump administration's legal wrangling over deportations and what the implications are for the rule of law. Joining me to talk about this is Harvard Law professor Noah Feldman, Bloomberg's columnist on all things constitutional. Noah, thank you for joining us this morning.
Thanks for having me, Sarah. Nice to see you.
It's nice to see you too. I thought we would just start with the law that Trump used to justify his deportation of about 200 accused members of a Venezuelan gang. It's an 18th century law that probably most Americans have never heard of before. And I thought you could just start by giving us some background on what that law is.
Yes, ladies and gentlemen, your morning is going to begin with the Alien Enemies Act of 1798. And I bet that was not on your bingo card for today. This is a law that goes back, as you can hear from the date, almost to the beginning of our constitutional republic. And it's designed for a very specific purpose, which is a very old school purpose, which is that when the United States is at war with another country, the idea is that citizens of that other country who are living in the United States are liable to being deported from the United States and indeed detained. And it's been used 3 times in our history, all of them involving actual wars that the United States was fighting with other countries. Most recently and most problematically, during World War II, it was used to deport and in part to detain Japanese citizens who were living in the United States.
So this law, Trump has brought this law up again. Do you think that this law actually applies to the situation, even if these accused gang members are actually members of this Venezuelan gang?
My technical legal answer to that, Sarah, is it's not even close. What the law says is that if there's a declared war, it applies. There's no declared war. Then it says if a foreign government is invading or conducting a predatory incursion into the United States, it applies. Well, Venezuela is not invading the United States and is not involved in a predatory incursion into the United States. And last, it says if an invasion or predatory incursion is threatened by a foreign government, then it applies. Again, not the state of affairs. So you may ask, how on earth is the Trump administration even claiming that this law applies? I don't mean to take the question away, but if that's a fair next question, maybe I'll answer it. It's fair?
Yes, that's fair. I mean, yes, go ahead and answer that question. Then I have another one.
Okay, fair. What the administration is claiming, and they did so starting in a presidential proclamation, that's what it's called, that Donald Trump issued over the last weekend. What they're saying is that the gang that is a Venezuelan gang with which the deportees are alleged to be affiliated is effectively either part of the Venezuelan government or operating in Venezuela independent of the Venezuelan government. And as you can hear, those 2 things are in contradiction with each other, but we'll let that pass. And that gang should be treated as though it were a foreign government for purposes of the law. And that's not all. They're also saying that because some of its members are in the United States, where they're allegedly committing crimes like drug trafficking or trafficking in human beings, that amounts to effectively an invasion or a predatory incursion. So there's 2 huge "you must be kiddings" in there. The first "you must be kidding" is that this gang is the government of Venezuela in some way or counts as a government. And the other is that this gang is invading or threatening to invade the United States. So it's really, this is why I say not even close.
Yeah, let's say then, for the sake of argument, that you are advising the Trump administration, and this hasn't happened yet, and they're saying we want to deport these 200 Venezuelans that we think are a gang member. What would a better legal argument be? I mean, are they using this Alien Enemies Act because there's no better legal argument, or would there be a more readily sort of available normal legal argument that they could use?
There's a whole range of legal arguments they could use to deport people, assuming they really are gang members from the United States. And all of them would be better than what they're using. So I'll say what those are, and then I'll maybe speculate about why they're not using them. First of all, these folks are alleged, at least by the government, to be undocumented. So that's on its own grounds for deportation. It would take a couple of legal steps. You have to show that they are in fact undocumented and give them a chance to show that they have documents if they do. But otherwise, that renders them deportable and they could be deported. Even if they did have documentation, if they are criminals and have committed crimes, they can be deported on that basis. If they belong to a violent organization that has been designated by the State Department as a foreign terrorist organization, which they're alleged to be, then they can also be deported. So there's a whole number of different things that ordinarily the government could and would do. So that leaves your second question: why are the Trump folks using this 1798 law that doesn't fit the bill? And I think there's sort of, this is pure speculation, but part of it is they like a headline and they want to be able to say we acted without any process at all. We grabbed these people up, we put them on a plane, and we sent them off. As a matter of fact, they didn't send them back to Venezuela, they sent them to El Salvador. But the idea is a headline that says, we just did this. Another is that the Trump administration may actually welcome the headlines that they're getting by acting in a way that is at odds with the law and, as we'll discuss, potentially at odds with a court order issued by a federal judge. Every time the administration does something that's illegal, that they could easily have done legally, and let me say they've done that dozens of times over the last couple of months, you have to ask, why are they doing that? Sometimes it's they want to establish a legal principle in court, but most of the time I think it's that they've learned the trick, which is that we who participate in the media and see our jobs as saying so when the administration violates the law, and to be clear, I think that is our job, we then make a fuss, and organizations that bring lawsuits make a fuss, and then they get more attention for what they've done than they would have done if they hadn't made a fuss. And there's something perverse about that, because I don't think we should stop doing our jobs and close our eyes when they do something illegal so as not to give them headlines. But on the other hand, we're giving them headlines.
Yes, and I think people can probably think of a lot of the examples. One very simple one would be the firing of the inspectors general, which just required a brief notification period and would have been completely legal, but the administration ignored that, and then there was this huge uproar about it. So I think my next question for you gets to that point of whether Trump has defied a court order. I mean, that is the sort of big question I'm hearing debated this morning. And I think at noon, there will be a new hearing in the case of these Venezuelans to determine exactly what time the planes took off and whether the administration had received the notice, in time. So we may get more information on that later today. But, in your view, is it clear whether the Trump administration actually has yet clearly defied a court order?
Well, I think the one thing we can say is it's not yet clear that they've technically defied a court order. It is clear that they defied the spirit of a court order. But because this is a legal question, the letter matters. So
Okay.
just to tell you the state of play as it currently has been reported by various excellent reporters, by Josh Gerstein over at Politico, and then more recently by the New York Times. The background to this is that the ACLU brought a lawsuit in the federal district court in Washington, D.C., and it was assigned to a judge called Judge Bosberg. And they originally brought the suit on behalf of 5 named Venezuelans who said, we're worried we're going to be deported. And the judge initially issued an order to the government saying, don't deport those 5 folks. And the government hasn't deported those 5 folks. Then, when the ACLU realized this was going to be extended to other people, they went back to the same judge, because the case was already in front of him. And they said, hey, we want you to issue an order that says that the administration can't deport anyone under this 1798 law. And the judge did that in a series of hearings. And he did it first in what they call an oral order. In other words, he said it to the lawyers in court from the bench. And he seems to have done that around 5:30 in the afternoon on, I believe it was Sunday, or was it Saturday, Sarah?
It was Saturday, I think.
Saturday.
Don't quote me on that, but I think it was Saturday.
Yes, we can't be quoted, but we're nevertheless on air.
I know.
And from the bench, he initially said, if I don't want anyone to be flown out of the country, and if they're in the air, I want the planes to turn around.
Yes.
Then a couple of hours later, close to 7:30 p.m., he wrote a written order which said no one may be deported under this rule, but it didn't mention the planes. The facts seem to be, as much as we know now, that around the same time that the judge issued the verbal order saying, turn the planes around, two planes were already in the air and a third hadn't left yet. And the administration did not order those two planes to turn around. And then it subsequently let the third plane also leave. The administration says we were following the order that was written, which didn't mention the planes being in the air. And their claim seems to be that the third plane had already left. Well, their third plane, which left definitely after the judge issued the oral order, wasn't covered in some way because of the fact that the judge in the written order didn't mention the planes. That seems to be their position, as far as we can tell. So I apologize for all that technical detail, but that's where we are. And so you can tell from all this that they knew that they weren't supposed to deport these folks. And if they were in the air, they were supposed to turn them back, and they ignored that. But they have this technical fig leaf, and it's really just that. It's a fig leaf that says, well, the written order didn't mention the planes, and so what we did was okay. And I think it's important to note that the official line of the administration, its Department of Justice filings in front of the court, has been, we did not violate the judge's order. That's their claim so far.
Yes, and that is similar to their claim in a different case involving a doctor from Rhode Island who originally is from Lebanon, who is here on a visa, where there is a lot of this similar sort of back and forth about the exact timestamps of the orders and the exact time that those orders were or were not received by people in the airport. And I'm just wondering, that the administration spokespeople have said, there's generally confusion sometimes about missed emails or crossed wires, and this isn't that big a deal. Is that true? Is it normal for this amount of legal wrangling to be taking place over whether an order was oral or written or sent at 7:25 versus 7:45?
No, this is not normal. The sentence that I have said the most times to the most people and in the most number of venues about the last 2 months of the Trump administration's wrangling is, this is not normal. The government usually bends over backwards to listen to the court and to really fulfill the orders of the court, and they're clearly not doing that here. In the case of the Brown University physician who had a valid visa, an H-1B visa, landed at Logan Airport, her lawyers seem to have anticipated that she might be excluded from the country, notwithstanding her valid visa. So they took the unusual step of going to, again, a federal district court judge in Boston and getting an order that said, don't send her back. And then her lawyer went to the airport without a written order in hand, to be clear, with a phone line to a judge. And then the lawyer went to the DHS ICE office at Logan and tried to get someone to listen to her, to say, I have the judge on the phone and he's ordering for this person not to be sent back. And by the lawyer's account, she basically couldn't get anyone to pay attention to her. And then, sure enough, the doctor was sent back to Lebanon via France.
Yeah.
So again, not normal. I will say I've spent a lot of time in that airport. I know you have too, Sarah. To be fair, there are many moments when one is trying to get someone's attention where it's not possible to get their attention. So it seems not outside the bounds of possibility. But the judge in that case, the federal judge, has said from the bench, I followed my usual practice, or the court's usual practice, when we have to issue an order, and we've never had this particular problem before. So in general, the headline is, this is not normal.
Yes. And I think, this gets to a question that one of our viewers has just asked, which is, I feel like the question is about due process. Do we even know if these Venezuelans are gang members? Is there any proof of this? I mean, that's the kind of thing that normally would be hashed out, you would think, in some kind of hearing. And I think similarly for the doctor, they were concerned by her interview coming back into the airport. There normally would be some kind of process. Is that correct?
Well, yes and no. I mean, it's absolutely right that ordinarily, if the government is going to deport you, you should get some form of process where you can try to say to the government, I am here lawfully.
Yeah.
And if the government acknowledges that you have a valid visa, before it removes you, it's supposed to give you a reason so that you have some mechanism for leaving. If you're undocumented, it's a bit more complicated. With respect to the airport, that's not always as clear. There are people with valid visas who sometimes do get turned around discretionarily at the airport. And it's not always the case that they get a clear explanation. If you're not, the difference is if you're in the United States already, you ordinarily have more rights. This is a generalization, but it's generally true. You ordinarily have more rights against being removed than you do if you're entering the United States and you're not yet in the United States. Then you have usually fewer due process rights and sometimes no due process rights because you're not yet in the United States.
Right.
So there's some complexity to that part of it. But the questioner is exactly right to say that there's a fundamental due process question when the government is invoking some old law just to say, well, you have this status, and so we're kicking you out, because people should have the opportunity to say, I'm not a Venezuelan, or I'm not a gang member. And then eventually their lawyers should also be able to say, well, this law that you're claiming to use to deport me isn't a valid law as applied to me, and so I shouldn't be deported. And yes, those are the basic components of due process. And in that sense, they haven't been afforded here.
Yeah. And I think so. I think that's why you're seeing people in the press refer to them as accused or alleged gang members because there's, you know,
We only
no.
have the administration's word for it.
Yeah.
And even if they were, being doing due diligence, which that we have no reason to believe is the case, there could still be mistakes
Right.
along the way.
Okay. Another question from one of our viewers is, are the judges causing a constitutional crisis by extending jurisdiction so broadly?
Well, that's a great question, actually, and that I'll take it as a two-parter. The first is what's a constitutional crisis, and the second, if there is one here brewing, who's causing it? I think, and to be clear, if you look up constitutional crisis in the dictionary, you might find different possible definitions. But my definition that I've been using, for the last 10 or 12 years in every context is a constitutional crisis is when two different branches of the government, here, the judiciary and the executive, are staring each other down, and each is telling the other to do something, and the other is saying, no, I won't do it. And there's no clear answer in the rule book for what's supposed to happen next. So if a judge issues an order directly to the executive branch and the executive branch openly says, no, I won't do it, then you have the makings of a constitutional crisis right there, because there's no clear answer in the rule book of what happens next. It's not like Congress can come in and resolve the problem. Under the Constitution, the president's supposed to do what the law requires, and the judge is supposed to say what the law is, and so the president's supposed to listen. And if he doesn't, there's a question of what would happen next under the Constitution. So that's a crisis. So now who's making it? Well, in a sense, that's in the eye of the beholder. If you think that what Trump's actions were in this case obviously violate the 1798 law, which, as I've just told you, is my own view, and a judge says, hey, wait a minute, I have to figure out if you're violating the law, so don't do anything until I determine what the law is. And the Trump administration were to say, which they haven't said yet, we don't care, we're just doing what we want, we don't think we're bound to listen to you, then in my view, the Trump administration would be creating the crisis. But let's imagine you think that the judge is completely out to lunch and that the Trump administration was acting lawfully. And some judge said, you can't do X. Well, the Trump administration would have something available to it. They could just appeal, and they could go to the Court of Appeals. And if the Court of Appeals won't listen, they can go to the Supreme Court. And then if the Supreme Court listens, they win. And so in that sense, the Trump administration wouldn't have to ignore the courts. But if the Supreme Court, with 6 conservatives and 3 Trump appointees, were to rule against Trump, and you still believe that the court was completely wrong and Trump was completely right, then you would say, oh, it's the fault of the judges. It's not the fault of the Trump administration. So in that sense, it does depend on what you assess the underlying law to be. But the bottom line is the Trump folks are supposed to appeal if they don't like what the district court did, whereas the court can't appeal to a higher authority if the president doesn't listen, because the president is the highest authority in the executive branch.
Yes. And in a sense, historically, the courts have given the president wide latitude over foreign affairs. And it seems to be under that latitude that Trump and, J.D. Vance has also spoken about some of this, is pursuing some of these deportations, portraying it as part of his conducting of foreign affairs. And that's true also in the case of the Columbia student who was being detained. Trump has portrayed him as essentially a terrorist sympathizer, and so thus it's in his capacity to detain him. Do you think that that is a valid argument? Is that an argument that is likely to stand up?
Well, although Vance and others, who frankly should know better because Vance is a lawyer, are exaggerating the case, it's not actually, the argument is not that, to start with, the argument is not, the correct argument is not that the president can do whatever he wants in foreign affairs and this is foreign affairs. The correct argument is Congress has passed laws that give the president a lot of discretion over immigration. And sometimes there's foreign affairs consequences to that. And therefore, laws like that should be laws that give the president a lot of discretion. And that is a valid legal argument that in some contexts would be correct. And you're right that in different contexts, the Trump administration has been invoking that argument. In the case of the 1798 law, I think that argument is a bit overstated because what the law actually says is not that the president can determine that we're at war with someone else, that we're being invaded. What it says is if we are actually being invaded or we are actually at war and the president issues a declaration saying so, then the president has these authorities. So there's first a factual question, which is like, are we at war? And if we're not, at least in my view, the statute doesn't give the president the authority to claim that something is happening that isn't happening. That seems to be not what the statute is saying. So a claim for broad executive discretion here, which the administration has already made in court, seems to me to be substantially overstated. In the case of the former Columbia student, Mahmoud Khalil, the situation is a little different. There is a federal statute on the books that the administration has invoked. And it says that if the Secretary of State of the United States determines that, in his view, a person who is not a citizen, with respect to a person who's not a citizen, that person's presence in the United States poses an adverse foreign policy interest for our country's foreign policy, that person can be deported. So that's on the books. And the statute does give that authority to the executive branch. The question is that law constitutional when the way the government applies it is to say that somebody has views that the government doesn't like, that otherwise would be fully protected by the First Amendment. And on that basis, they can kick the person out. And there, although the court has not yet said this, no court has said this yet, it seems very clear to me that the correct legal answer that the courts should and will reach is that that law is not constitutional because it amounts to punishing someone by kicking them out of the country for free speech, namely expressing their political views. And to be clear, if you say the words, I think terrorism is great, I support terrorism, that is not a crime in the United States. That is, in fact, protected free speech. What's a crime in the United States is to materially support a terrorist organization. And the Supreme Court has said that if you're going to do that, you have to do it by actively working alongside that terrorist organization. Now, you could do that in a way that involves talking, but if you are not working alongside that organization, if your advocacy on behalf of terror is uncoordinated with the terrorist organization, it's totally on your own, then your free speech protected. And the government has not alleged in the case of Khalil that he was working with or for a terrorist organization. They've only alleged so far that he spoke in a way that was supportive of terrorism. And they've said specifically, we're not kicking him out for that. We're kicking him out because the Secretary of State has said we don't want him here in the country. And so they've said overtly that it's because of speech that would otherwise be free speech protected. Under those circumstances, I don't think the president's discretion in foreign policy matters should be sufficient to overcome the First Amendment itself. Oh, and I should add to that, if you're a lawful permanent resident, if you're a green card holder, the Supreme Court's been holding for more than 80 years that you have full free speech rights the same way that you and I do.
Mm-hmm. So I feel like as we've bounced around to these different cases, we've got the 200 alleged gang members from Venezuela. We've got this doctor from Brown University who had allegedly, according to the government, had sympathetic Hezbollah photos on her phone. And you've got this pro-Palestine protester from Columbia University. The principles here may be important, but I think to a lot of people in middle America, these are not terribly sympathetic targets of the law. And I'm wondering if you could talk about why these principles should matter to middle America, even if they don't find these defendants especially sympathetic.
The point of the First Amendment, so let me start there, because free speech is the single most important of these issues, in my view, at least to begin with, where it's clearest. The point of the First Amendment is to protect the free speech of people here in the United States. That means citizens, and according to the Supreme Court, it also means permanent residents here who are not citizens. That free speech right is one of our most cherished. It's something that the Trump administration came into office saying it was committed to. And if one person's free speech rights are taken away, it sends a message to everybody else who has those free speech rights that you could be next. That's what's called in First Amendment language the chilling effect of taking away someone's First Amendment rights. It chills everybody else's speech. And so, there, the whole point is freedom of speech, not just for the views I like, but freedom of speech for the views that I hate. So, there, the fact that you really don't like what someone believes or has said should not be a reason for you not to support the First Amendment. In fact, arguably, it's the opposite. If you see that someone who has views that you really hate is having their free speech taken away, you should be nervous that someday they're going to take away your free speech rights. And so that's at the First Amendment level why you should really care. With respect to the government following the law accurately, when it takes actions that fundamentally change people's lives, like in the case of the alleged gang members kicking them out of the United States, there the consideration is twofold. First, these are human beings, innocent until proven guilty. And the whole point is of having a due process and having a legal system is that there are rules, and the government can't just grab people up on the street, announce that they don't have any rights, and throw them out of the country. Because if that happens to somebody who's alleged to be a gang member, it could also happen to your neighbor or your friend or your coworker who isn't any of those things, but is falsely thought to be one of those things or is alleged to be one of those things. And last but not least, with respect to someone who's on a visa, a valid visa to come to the United States, who is a transplant surgeon, a physician whose job it is to enable, I believe she's an expert in kidney transplants. The reason that the United States and Brown University, which is one of the great medical centers in our region and in the country, wanted her to be in the country is that she has a skill set that not enough American-born doctors have. And that's why they got her an H-1B visa, which is a visa specifically for people who have a skill that we need in the United States. So the consequence might, if you don't care about the physician herself, you might think about the people who are in line waiting for a kidney transplant and need doctors who have the expertise to make that happen. That's something that has nothing to do with the particular person. So at a minimum, we want the system to work. We want the law to be followed. And we want people who have valid visas to be able to enter the United States if it's lawfully appropriate for them to do so.
Mhm. Thank you. I feel like that explains well the impact of this on ordinary people's lives, and on principles that have been important to America for hundreds of years. I also want to ask you, I guess, as my last question today, about the impact on the presidency. The US presidency has started out as a relatively weak position and over the centuries has become more and more powerful in our government. And I'm wondering how you think, if the Trump administration is successful in shifting some of these norms, where do you see the presidency headed in the future?
Well, there's no question that in the last 2 months, the Trump administration has tried to vastly expand the power of the presidency to do all kinds of things that are, strictly speaking, against the rules as they currently exist. And that includes unilaterally firing people in the government whom Congress has ordered to be hired and who are doing their jobs. It includes running roughshod over more senior administration officials and firing them when Congress has said they can only be fired if there's a good reason or if there's a procedure that's followed. It includes cutting funding for purposes and to institutions that the administration doesn't like when Congress has passed the laws requiring that funding to be spent. These are all examples of gross exaggeration of presidential power. And the examples we're talking about today in the immigration context are also examples of expansion of presidential power over and beyond what the pretty deferential laws already afford to the president in these areas. And so the overall explanation has got to be that the Trump folks want to maximize presidential power. They're not even satisfied with the vast power that the presidency already possesses. What's scary about that is that we have a system of government that's based on the idea of the separation of powers, because of the idea going all the way back to James Madison that we're freer and safer if we have different branches of government that counterbalance each other. It's the most basic idea in the entirety of our constitutional design. Congress is doing not much these days and seems almost to be out of this conversation. There may be some cases where it tries to quietly exercise its power to reinstate people whom Doge has ordered fired, but that hasn't happened yet, and it's kind of hopeful that it'll happen. It may not happen. And that leaves the other branch, the judiciary. And the judiciary has been the part of the government that's been standing up. There have been 126 cases brought against the Trump administration thus far. A couple of them have been resolved, but 124 of them are alive in one form or another. And in most of those cases, there's been some either finding or hint by a federal judge that says the Trump administration has gone too far. And that's one of the reasons these cases are still alive. And so that's a lot of instances in which the judiciary is trying to stand up to the presidency. The reason that matters to all of us is with Congress not doing much of anything, unless the judiciary is successful in standing up to the presidency, the separation of powers and the fact that there's supposed to be a balance between them is going to be not only weakened, but potentially put in a position where it could collapse. And that's what an authoritarian government is. It's a government where there's a president who's just grasped so much power that the other branches of government don't really matter anymore. We're not there. I have every hope that the lower courts, which are doing a pretty good job, will stand up to the president, and that the Supreme Court, which has heard exactly one case so far on this issue, but has, in an interim order, decided against the Trump administration and in favor of a federal judge, will also stand up to Trump. But this is what a stress test of our Constitution looks like, and we're in it. And it's really, really, really important that we get through it successfully, which means that we get through it with a strong, independent judiciary that can stand up to the president when he violates the law.
Noah Feldman, thank you for talking with us today. And thanks to everyone for watching. That's it for this Bloomberg Opinion stream. We'll see you next time.